Hello, everyone. Thank you for joining us for the next portion of our cross-training series. This one's on court-ordered evaluation, court-ordered treatment, and rule-of processes. There is a chat going. If you have any issues, any questions, please enter into the chat. And I'd like to introduce our guest, Ms. Devin Forrest from the Guidance Center, to deliver the presentation. Thank you.
Thanks. And I'm going to be joined by Dr. Stephanie Babbitt, the Guidance Center's Chief Clinical Officer, and Nathan Jones, our Chief Counsel and Chief Compliance Officer for the Guidance Center. So, and I'm going to speak very little, I promise. They know a lot more. I will introduce the fact that there was a training I just learned of that was a couple of weeks ago from the other perspective. This will be very similar, but we'll flavor it with a little bit of the behavioral provider perspective as well. And a little bit of background, the Guidance Center does have the Coconino County Title 36 involuntary commitment at the time, so we are the ones that are receiving these quarterly evaluation petition, very much, and the ones managing that title process from the evaluation side. Forward button. Is it forward?
Is it working?
No. No, nothing.
Telling you, there's always clicker issues every single time.
Yes.
There it is. Do you want me to click for you? Yeah, sure. Okay. We'll trade. We brought assistance. Just give me a signal.
On.
Oh, it was. It was the first time. Thank you. Okay. Went from green to red. Okay, so we included this slide, and some of you may notice it as an old access slide. Access is no longer directly involved with this process, but this slide is perfect and we don't want it to change. So we did want to include it. This overview is a little bit busy, but what we really wanted to highlight on the slide is that there are two separate processes for titling an individual. One is the emergent process where that person can come straight into that evaluation, then the petition goes to the court, or we are screening them first, and that's the non-emergent process. And we will come back to this slide at the end because I'm sure there will be questions about it, but right now it's just a bunch of arrows. And that's the overview that we'll be hitting on as far as the COE and COT part is concerned today, and we'll throw Rule 11s in at the end. So I'll cover the application process, again, those two forms, involuntary and emergency admission. The application for involuntary evaluation requires those three things. It requires pre-petition screening, a review of the application, including investigation of alleged facts, an interview with the applicant, and an interview with the patient. The screening has to be completed within 48 hours of that application being filed and result in a written report of opinions and conclusions by our professionals. It may result in a petition for COE, voluntary evaluation, or nothing at all. The other application type is application for emergency admission. Anecdotally, this is what we see the most here in Coconino County. It seeks admission for evaluation without that screening process, so without that 48-hour timeline beforehand. It must allege that the patient is dangerous. When the patient is not presented to the agency, a peace officer may be advised to go take the patient into custody for transport to that evaluation agency. The agency's acceptance of the patient for admission equates to decision to petition for COE. So when we accept that, then we will send in that petition. The petition must be filed that day or the succeeding court day, and the patient cannot be held for more than 24 hours before that petition filing occurs. 24 hours is the long end of that. We really like to get them in earlier than that. That's you.
So, hi everybody. In case you don't know me already, I'm Nathan Jones. I'm the in-house attorney for TGC. Prior to that, I've been on the Riva side Devin as well, so we've got a long history, been practicing law about 15 years and you know, in this system since 2011. Anyway, a lot of this is me because the county attorney's office represents us in the hearings for these by statute. But obviously there's this whole application process. And then generally, these orders are going to, the resulting orders for treatment are going to be a year in length. And so there's a lot that happens before or after those hearings. And so anything that's before or after those hearings is where I tend to be involved. So I do want to back up just a little bit because this slide needs a lot of emphasis. It's key to the whole thing. Frankly, really summarizes the entire presentation in a lot of ways. And we look at these differences, right? So, and by the way, I should say at the outset here, for brevity, you're going to see time frames all over, 48 hours, 24 hours, what have you. Just be aware that in every statute that has such a time frame, they exclude weekends and holidays because the courts just aren't open. These are civil cases. All right, so just imply a and excluding weekends and holidays addition to any time frame I give you here. So I don't have to keep saying it over and over. Anyway, that primary distinction here between these non-emergent and emergent processes is, look, as Devin mentioned, look at the absence of a pre-petition screening. So in an emergency, we're basically, as well as the timing of the COE petition. So the whole point of emergency, which is what most people mostly use up here, is that you're saying, hey, it's an emergency. I don't have time to go to court, right? So we get this 24 hours excluding weekends and holidays where they're already in our custody. So that creates two things that can seem interesting to stakeholders. One is that when the application comes in, we're reviewing the application, doctor may need to talk to the applicant, but we're not necessarily seeing the person face to face. The mobile crisis often will, you know, because they can come out and help people fill out the applications, maybe improve the quality of the application process. But the statutory phrase, 36.524E to be specific, is that the admitting officer at TGC in the emergent process has to make a decision as to whether there are quote unquote reasonable grounds to have the person transported to the agency from wherever they are if they're not already here. That reasonable grounds evaluation is there presumably because, well, you know, it's law enforcement that's supposed to do those transports, and putting somebody in handcuffs in the back of a squad car is an inherently traumatic experience. Someone should not be subjected to it unless there appears to be reasonable grounds from the petition. And there are a number of exclusions that I think we get into later in the presentation that are just not defined by statute as mental illnesses, although they can co-occur with mental illnesses. So doctors are trying to make these decisions, these reasonable grounds decisions, based on what's presented to them by the applicant. All right. And they're trying to protect people's civil rights at the same time as making sure that people who really do need to get into the process do in fact get into it and get transported here against their will, if need be, or get transported to TGC against their will, if need be. So, you know, they've got to think about those exclusions, those criteria. And they're doing it in the emergency process without the benefit of the pre-petition screening. So, because it's an accelerated process. So we do like people to be aware of the other option. And then for law enforcement, it's the same thing. It's an understanding that a pickup order is not going to be a court order if the applicant is using the emergency process. It's going to be an admitting officer decision to essentially direct law enforcement to take a person into custody. If using the non-emergency process, Well, then they're not here yet. It's not an emergency. So we're going to petition the court for a court ordered evaluation. That'll include a transport order and we'll give that to the police. So emergency, you don't have time. Okay, so back to where we were. As we said, and by the way, credit where credit is due, the vast majority of these slides are just taken from the presentation that we have on file that the former Chief CCAO Civil Deputy Rose gave. So I'm getting the vast majority of this text from her. I'm trying to pinch hit for her. She was fantastic. Now she's in private practice, but I miss her. I bet the CCAO does too. Anyway, petition for court ordered evaluation. That criteria we're talking about, which in an emergency, a doctor is trying to make this call based on what's presented to them, as I mentioned earlier. So do we have these reasonable grounds to believe that the patient has a mental disorder? That's the first one. It's not as straightforward as you might think because there are some statutory exclusions to the definition of a mental disorder, such as substance use disorder is not a mental disorder for purposes of Title 36. Again, it can co-occur. So I'm not saying it's an exclusion. I'm saying you can't title them just for that, right? Developmental disabilities, same thing. Another one is antisocial personality disorder. These are lifelong and deeply ingrained personality characteristics often associated with criminality. And I don't want to speak for the legislature, but I'm assuming that their motivation was probably related to the fact that there isn't medication for that issue, you know, and also they wouldn't want, they give one specific example of a of conduct that is sort of presumptively due to a personality disorder, and that is sexual behavior that is abnormal and prohibited by statute. So not supposed to, phrases such persons, quote, shall not be considered for the Title 36 process unless they also have a mental disorder that would benefit from treatment. As a result of that mental disorder, they're a danger to self or others, have a persistent or acute disability or a grave disability. And lastly, that they're unable or unwilling to either undergo a voluntary evaluation or simply consent to treatment. That last one's important because we do need them to be unable or unwilling. And so sometimes this can come up, you know, like another stakeholder might say, well, I don't want to, I want to be absolutely sure that this person will be under court-ordered treatment before I release them from this other thing, or before I'm comfortable doing this or that. I can't guarantee that we'll take the process all the way through. This is not a crime. It's, you know, it's not a crime where if you've exhibited the behaviors, you're going to get a COT order, because if they consent to the treatment voluntarily, we're going to have to drop. And I mean, we've seen this come up at hearings. What exactly is unable or unwilling? How unwilling can you be? You know, we had one case where we were like, it's kind of on the line, so we'll take it to hearing and see what happens. And you know, the person had taken, you know, they were demanding to leave, but they took one pill out of the many that were recommended. That one piece of voluntariness convinced the judge to drop the case. So said, well, he consented to something, so that was enough. So our experience has been that any ambiguities or gray areas tend to get construed in favor of the patient's civil rights. All right. So the petition is going to state whether this is our petition for court-ordered evaluation, which again will be filing before they get here in the non-emergency process, or within 24 hours, excluding weekends and holidays, after they get here in the case of in the case of the emergency process. So we're stating whether we believe, whether our doctors believe that without the hospitalization, they will suffer serious physical harm or further deterioration. And whether the evaluation should take place on an inpatient or outpatient basis. As a practical matter, it's almost always going to take place on an inpatient basis. So the inpatient evaluation will be completed within 72 hours, again, as always, excluding weekends and holidays, right? And then at the conclusion of that, they're either going to go voluntary, they're going to be determined appropriate for discharge, or will proceed for a court-ordered treatment petition. And incidentally, that whichever of those three things comes first is the end of the county side responsibility. And that's where the REVA picks it up if they are Medicaid eligible or if they're SMI. If they're not, that's a whole other topic. So, all right. And then outpatient evaluation, as well, by the way, as the non-emergency COE orders are all going to say at the bottom of every court order, will just say this order expires within 14 days if the person isn't, if the evaluation doesn't begin in that time. Covers situations where, you know, like I said, non-emergency, they could be out in the community. So if the police aren't able to apprehend them, that's how long that order is good for. All right, so now we're in that 72-hour evaluation, right? Court has approved it. By the way, that's an ex parte process, so we'll file the application. Court order will come back the same day or the next. It'll appoint counsel for them. It'll specify, it'll also include an order for detention, which is our authorization to continue to hold them, so on and so forth. So we need 2 licensed physicians to do the evaluation. By the way, as I mentioned earlier, a lot of this presentation is Rose's text, and so it's from 2018. There have been a few statutory changes since then. I do mention them when they come up. One of them is there is a movement to allow one of the 2 evaluators. There is a statutory change to allow one of the 2 evaluators to be a nurse practitioner. We're still considering whether to use that.
Effective date 10.
Yes, effective date up to whatever the general effective date is for brand new legislation, because it just passed this last session. It's however many days after the end of session. Anyways, evaluations can be done independently, could be done remotely over telemedicine. We have rooms for that we'll put them in. And then there's 2 other individuals who participate, psychologist or a social worker. And this often conflates too with something you'll see in the statutes about what they refer to as the acquaintance witnesses. So happens in Coconino that defense always stipulates to the acquaintance witnesses just writing letters. I suspect that's because we use what's known as unit witnesses, people who work on the unit but aren't necessarily involved in the treatment team, serve as the acquaintances because they become acquainted during the stay. This is helpful because down in Maricopa, you're going to see a ton of appellate case law that centers around around who can or around the acquaintance witnesses. They don't like to use. It can be like a family member or a friend or whoever the applicant is, right? But if you tried to rely on those folks, they might not show up to the hearing. And so a lot of cases in people that don't, for providers that don't use acquaintance witnesses, get dropped for that reason. Fortunately, up here, it's unit witnesses, so they're going to show up, and our experience has been that stipulations are mutually agreed upon to use those letters in those cases because they just come anyway. There's no doubt as to whether they'd show up. And there needs to be a physical examination if possible. You know, there's lots of case law that basically the patient can't resist the physical exam, and then when the case, by virtue of making it impossible to perform. All right, so the outcomes of that evaluation. We might release them. if they're appropriate, they're not found to meet any of those Title 36 criteria. They might be admitted for voluntary care because they consented, or if that unable or unwilling requirement are met and all the other criteria is met, we'll petition for court-ordered treatment. And when that happens, we are making sure that they meet the criteria, as I mentioned, they're unable or unwilling. We have to talk about treatment alternatives that are appropriate or available. A lot of controversy about 14+ guardianships, whether they can substitute or not. We say, no, they really can't, because police policy is that they won't assist a 14+ guardian just because of the 14+ guardian. So if a lot of compliance help is going to be needed, it'll probably still proceed. Anyway, we have these physician affidavits that have to be included. Even though the physicians are going to testify, that can be stipulated too, but usually the physicians are going to just testify at the hearing. Grave disability, especially a big emphasis on why guardianship wouldn't suffice, as I mentioned. Whether the court should order independent investigation, request for that, it's all in there, but you know, oftentimes that's going to end up with the public fiduciary or something else that isn't our, isn't our agency. So I won't go into too much depth on that. This one time, this period of time after we have filed a petition for court-ordered treatment, but before there's actually a hearing. This is the only time that we would need court approval to drop it. Obviously they need to vacate the hearing, among other reasons. Otherwise, 72 hours expires and we haven't filed a COT petition, court just loses jurisdiction. There's nothing more to file. So, okay. As I mentioned, we have that order for detention. The petition for treatment is going to seek, that detention continue until the hearing. Court has 6 business days to schedule that hearing. Patient has to be served at least 72 hours in advance. So that kind of limits the ability to go less than 6, doesn't it? And we got to coordinate that with the sheriff because they're doing the service process and all of that. So, okay. They've been served, hearings been scheduled, etc. Continuances. We can only request a maximum of 3 days. Patient could request up to 30. And why would they? It just prolongs their detention. Maybe, but they have other rights, like the right to an independent evaluator that doesn't work for the agency, i.e. a third evaluator, and that can take more time to arrange. So there are reasons they might ask for longer continuances. So the court could review the petition for treatment and dismiss it outright. But generally speaking, what will happen, again, defense counsel has been appointed, currently that's the legal defender's office. And we make ourselves an open book for them. They want records, they get them. They're supposed to interview the patient. We make sure they're not obstructed in that regard. We may want to be successful in these hearings, but not at the expense of doing anything or not doing anything that would in any way, interfere with defense counsel's ability to put on a good defense for their clients. So we want to make sure they have full access to the patient, to the records. They have to interview the physicians, all of which I try to make sure that they have no obstacles to doing. So we also, of course, have to make sure that any treatment they're getting, maybe they've consented to some things, or maybe there's been a medication that's been administered as what's known as a chemical restraint to manage an emergency safety situation, which our licensure regulations allow. But we try to make sure that we have to make sure that medication doesn't interfere with their ability to participate in the hearing. And that's those acquaintance witnesses that I talked about earlier. Stipulated statement is usually what happens up here for those two. Because we are using, like I said, typically other staff to serve as those unit witnesses. And finally, the outcome of the hearing. After the hearing, court could order inpatient only, outpatient only, or combined inpatient, outpatient. And in basically every case, I don't know if I've ever seen one in my time here that's been anything other than combined inpatient, outpatient. Arizona doesn't get enough credit sometimes, I think, for its extensive use of court order of outpatient commitment. Other states refer to this as AOT, assisted outpatient treatment. New York calls it Kendra's law. For a lot of places, it's this new exciting innovation, but here it's been around since inception. It dispenses with the notion that being committed means you go into something for like an extended period of time. Not so. You're going to be free in the community for the vast majority of the time. We don't necessarily like to draw criminal justice analogies here, but what it's probably most similar to, frankly, is probation. You're free in the community. It is known as conditional outpatient treatment. Your freedom in the community is conditioned on your compliance with your treatment plan. And if you are not in compliance and we can't bring you back into compliance in any other way, the solution is revocation. I'm in probation's office. Does the term revocation sound familiar to anybody? It's kind of a similar structure. Except we don't have any surveillance officers. So that means when we do the revocation, there's a statute that says the medical director of the agency is supposed to be able to direct law enforcement to take the person into custody and bring them back to the agency, quote, without necessity of warrant or court order. But not necessarily the highest priority. May involve long distances if they've left the county, et cetera, et cetera. It can be very difficult to actually get them back in sometimes. If that happens, there's a separate process also in 36544 called tolling, which essentially says they've left the area without permission or otherwise not compliant. We can't get them back. So the order just tolls. We file a notice with the court. Court issues an order in response that says, okay, the order is tolled. And we have to report back every X number of days on our efforts to try and get the person back. If those efforts succeed, then we file another notice, at which point the court computes how long it was tolled, because you don't get credit for time you didn't serve. So the order will be extended by whatever the duration of their absence was. If on the other hand, it's unsuccessful for a certain period of time, I want to say 180 days, pretty sure, and the court is satisfied that we've done all we can, then we notify them that we've tried for as long as we're supposed to try, and we can't get them back, and so the case just drops. And the court will then dismiss the COT order. So I went into that tangent because it's all linked to the combined inpatient outpatient treatment. How do you have such a creature as outpatient commitment? And that's how. So we're going to have a separate limit for inpatient days, like the order will be 365 days long, but an inpatient limit of say 180 or 90, depending on what which round they have found COT on, DTO, DTS, BAD, GD. And that's an aggregate limit. It's cumulative, not consecutive. So if we run out of the number of inpatient days, we run out of the number of inpatient days, even if there's time left on the order. This is a blunt instrument employed by the legislature, I think, to facilitate the laudable and good public policy goal of deinstitutionalization, trying to abolish the asylum, right? That is what it was really all about. So definitions. These are all statutory. I don't necessarily want to go into every single one. Danger to self and others is probably pretty straightforward. Grave disability, GD and PD to PAD are kind of linked, but they're mostly your ADL. They're gonna hinge on activities of daily living type problems. And by the way, in an earlier slide, you may have noticed that it says that for the emergency applications, that those are limited to danger to self and others. More statutory changes since 2018. They did change that to allow emergency applications for just PAD or GD, but guess what? The form to apply for an emergency application is a creature of administrative law. So it's a Arizona Administrative Register regulation, what that form looks like. Any guesses as to whether they started a rulemaking process to change the form? They did not. So the form still says DTO, DTS only for emergency applications and PAD, GD for non-emergency. But what I like to say there for applicants is two things. We could try the experiment where somebody just handwrites on PAD new statute, right? Or there's usually at least potentially dangerous things to allege if it really is an emergency anyway, because the grounds that they're ultimately ordered to treatment for are not necessarily the same grounds that were initially alleged. So somebody could be taken in on DTS, but ultimately found COT just for PAD. So there's that. Danger to self, kind of self-explanatory, but I'm sure these slides will be available and people can read it. PAD is kind of similar to GD in the sense of it focusing on these, this impaired judgment, reason, and a lot of crossover there in the not showering, not doing your activities, that kind of consideration. And I don't know if we didn't add the definition. I was going to add the definition of mental illness. But well, anyway, you can see it for yourself. It's 36.521.01. That's going to have the exclusions that I mentioned related to substance abuse, developmental disabilities, conditions impending associated with impending death. So inevitably fatal disorders that can't really be treated. Alzheimer's. There's no treatment for it. It's not a mental health condition.
Can I comment really quickly?
Yeah.
PAD, the definition that's is most commonly associated with that non-emergent process. So even though statute has changed to allow it to be filed under the emergent process, this is really the most common non-emergent reason.
It is, and incidentally, a common ground for both. They're not mutually exclusive. Somebody could be DTS and PAD. Somebody, a lot of cases come in as a DTS and PAD petition at the court level and base it on PAD. There are some other differences that we're not getting into here, probably for. Oh no, we do have it. Okay, annual review. This is only for PAD and GD. We call them the 90-30 reviews because we have to start the review no earlier than 90 days before the order expires and complete it and file the renewal application no later than 30 days before it expires. And that part is within that filing to continue it. That's within the scope where county attorney's office represents us in that too. And so that'll go in, if they do the review and they decide that the order needs to be continued, it basically provides an avenue for having it continue for up to another year without needing to start the process all over. There may or may not be a hearing. The court can rule on it on the paper, but defense could request a hearing. Court might decide there should be a hearing, in which case it kind of cuts the number of witnesses in half, like it needs one physician witness and one acquaintance witness instead of two of each. And it provides this sort of semi-accelerated process or semi-streamlined process for renewing a PAD or GD case in recognition that those kinds of disorders are probably longer lasting than some potentially more acute phases. If it's anything else, if it's just a DTO or DTS case, it's going to expire at the end of whatever period the court ordered. which will usually be 365 days, and if it needs to go beyond that, then it will have to be a brand new application. It just starts over from the beginning. And so, that's my Title 36 super quick version. I always emphasize there are an incredible number of weird one-off situations that arise. Weird is how things make it to my desk. And so I work with whoever I need to work with, often it's county attorney, to try and figure out what to do with it. So don't expect this to cover every possible scenario you might encounter, but I hope it's a good overview. And the next thing is going to jump into Rule 11, which I'll turn over to Dr. Babbitt for. But before I do, are there any questions in the chat or out here that anything I should pause for?
I don't have anything in the chat right now. But does anybody in here have any questions? Cool.
No? All right. Rule 11 to me.
Woohoo. Forget everything you just heard.
Yeah. What she said. Remember, Rule 11 is not court order treatment. It has nothing to do with Title 36.
Thank you. Yes, so
Well,
don't forget everything you just learned. If you learned it,
you come out with incompetence to do that.
but completely different
Yeah.
processes and purposes, I suppose, because a Rule 11 is of course in order to determine whether or not someone is competent to stand trial. It is completely separate from the Title 36 COE COT process that was just covered by these two. And essentially, in order for this to even come about, the individual has to be facing criminal charges. And someone somewhere in the process has to have concern for their competency to stand in front of the judge and, I guess, for the trial to proceed. So in order to be found competent, they have to rationally and factually understand the legal processes that they are going to go through and that are being, I guess, charged against them. And they have to be able to assist in their own defense. And the evaluator or the mental health expert has to prove both of those things as part of their report in order to determine that someone is competent or opine that they are competent. I share this timeline because one of the main things that we hear back, we being the guidance center, is that like the Rule 11 process is taking forever. The defendant gets very upset. We get very upset. There are statutes about what the timeline looks like. The order from the judge will have timelines, like the defense attorney only has 3 days to get me, the mental health expert, all of the supplemental information. I get 10 days to write my report and give it back to the court. The court then has to file the next hearing within a certain number of days. But this timeline can take a really, really long time, especially if the person is in custody and unable to be located, because in order for me or anyone else to evaluate them, we have to know where they are.
Not in custody.
Not in custody, yes. So it all begins when charges are filed against a defendant. Someone somewhere, typically in Coconino County, is the defense attorney who has some concern for whether or not their the defendant is competent, and they typically will file a motion to determine whether or not reasonable grounds exist for a mental health person to be appointed. If the court determines that reasonable grounds exist, they will then submit an order that comes to the guidance center to say that one of the mental health experts at the guidance center, there are 3 of us. One is Dr. Chris Linsky, one is Dr. Deb Hardy, and one is myself. One of us will be ordered to evaluate the individual. We examine the defendant. 9 times out of 10, this person is incarcerated. What are you giving me 2 for?
Because it will be 2 unless they stipulated a 1.
So typically they should have 2 evaluators. Oftentimes in Coconino County, the motion will only ask for 1 expert. We can get into that. Also, because if you have 2 experts and they don't agree, a couple of outcomes can come from that. But ultimately, it's with the judge to determine whether or not they take the mental health expert's opinion, whether they agree with it or not. So once we examine the defendant, we have 10 business days to submit the report to the court, and then the court has a hearing where basically They hear all of the evidence and determine whether they agree with the evaluator, whether they disagree with the evaluator, or whether the evaluators are split if there are two, which often there are. Okay, so in best case scenario, the following outcomes will happen when someone is assessed for Rule 11. If the evaluator does their assessment and they feel like the person knows what's going on, they understand criminal proceedings, they understand nuances of their own case, they understand options for their own defense, and they can rationally and or factually contribute to their own defense, meaning work with their lawyer towards a coherent defense, we will opine that they are competent. Oftentimes the judge agrees with us, and then the trial will just proceed as if a Rule 11 order never happened. They can also be found not competent but restorable. 9 times out of 10, the person is sent through restoration. Oftentimes the mental health expert gives their opinion on whether or not we want them to go to Yavapai County for restoration within their jail-based program, or whether or not we want the individual to be restored at ASH. We visited ASH a little while ago. Their average length of stay for people is 10 years. So to get someone into ASH is an incredibly difficult road, but the Rule 11 process and determining that someone is not competent but potentially restorable is one way that they could get to the Arizona State Hospital. I didn't include it in this slide, but the judge always, of course, has the leeway to say they're not competent, potentially restorable, but we're not going to attempt to restore them, and so they can just drop the charges, like which would happen if they were found not competent and not restorable. Often the charges are dismissed. They might then be referred for the COT route. Oftentimes we're asked to determine whether or not that person would be appropriate for a guardian, because essentially we're saying they're not competent to stand trial and they shouldn't be held accountable for whatever actions they're being charged with. And then this is a little bit about the nuance. If an individual is found not competent but restorable, again, they go through Yavapai or they go to ASH for restoration. There are statutory timeframes for when the individual has to be restored by. I think it's 21 months. Do you know off the top of your head? It's either like 15 months and then you can get an extension. I think up to 21 months, but essentially, if they go through restoration and 2 years pass and they're still not restored to competency based on another mental health expert's opinion, they can either be sent again, or oftentimes the charges are just dropped. Yes.
I'm checking on this one just for a second.
Please.
Because of new statute issue.
Oh, yeah.
Right. There is a new law, and this is an interesting one because it's supposed to come into effect in January 2024. I was chatting about it a couple weeks ago with Ammon over at the county attorney office. This one is interesting. Not competent, not restorable, dangerous. What do? So historically, the courts only had 2 options, which is shunted to Title 36, like it describes here, or maybe appoint guardian. They created this new law that tries to make that situation work more like insanity defense. So there's a jury trial, but not on guilt or innocence, but rather based on a special different type of commitment that just got created. Basically they find that if the jury goes for it, like insanity defense, it results in the more conventional commitment to an actual facility. But here's what's really weird about it, and what really threw a wrench in the works, right at the last minute. What is that facility? That facility was going to be ASH, but then there was a floor amendment introduced by one rep at the last second to change the definition of a secure state mental health facility for this purpose from ASH to something called a secure birth. Problem is, those don't exist. So I think it may express some frustration with the fact that they had appropriated some funding to give out to establish these secure residential facilities. They either aren't getting built or they're just in Manitoba. We don't have one. It can only serve this. Either people on a very special type of Title 36 that I didn't have time to get into here, or people who go through this quasi insanity, not competent, not restorable jury trial thing that just got created. I don't know what's gonna happen. It's supposed to come effective in January of 2024, but the facilities it contemplates committing people to aren't there. So
And to add another wrench to that, they can be pivoted to really quickly, especially here in Coconino County. One of the problems is it's unclear how to staff for a level of demand that we don't know exists yet. So
right, because we can't mix use.
right, so we are not to create, we're not likely to create a 10-bed secure birth facility tomorrow.
Right, because the secure birth statute says it can only house those special types of people. You can't have any volunteers, can't have any regular Title 36 people. You can only have either the super titles or the NCNRs. So
So you'll
from an
notice,
economic standpoint,
many of these new statutes we did not incorporate here because they're so up in the air still.
right,
That we don't want to confuse the processes, so previews of coming attractions, probably coming later in spring. We'll have some
and
clarity.
I wouldn't have gotten into it.
No, I like it.
But I know, now that I know there's some CCAO folks here.
It's something we're talking about.
I know that's it, because Alan brought it up, so it's like, okay.
We'll see what happens. Any questions in the chat about that?
Do you have the bill number? You know the
I
bill?
can get it to you, off the top of my head.
Yeah, someone just
Afraid I
asked
don't
for
have
that.
those bill numbers.
Yeah.
But yeah, it's pretty easy to find.
I do have one question.
Yeah.
So what is restoration?
So the restoration is like a program through the state designed
Yeah,
to
well,
teach them about legal proceedings.
So it's not treatment.
it's both.
So we don't actually do this a lot. I have never done like restoration is contingent upon medication, for example, like that is something that you can opine in your report. Which often leads to a different outcome.
Cell hearing,
Yeah,
that's what I'm gonna get into.
So- but it isn't necessarily treatment. It's kind of like a class to teach them like, this is what a defense attorney does. This is what the judge does. This is what a plea agreement is.
Yeah, it's two components. One is the classroom component, which does exactly what you said. The treatment side of it is interesting. Because if you are gonna because the main thing that you probably wanna do in a lot of those is force meds. And that can be done if the restoration competency program at issue is willing and the prosecutor is willing to move for it. But there has to be what's known as a cell hearing, which comes out of the US Supreme Court case where the party name is cell. Anyway, it sets forth the sort of constitutional criteria for forcing meds on an incompetent defendant for the purpose of restoring competency. But it isn't for the purpose of making them get better or treating them, it's for the purpose of making them competent to stand trial. Which is why I'm always cautious about, don't try to use the Title 36 process as sort of shadow restoration of competency. Title 36 its purpose is treatment. Not to restore people to competency, there's something else for that, and so, when it is being restored, yeah, there's a process, court can approve forced medications. The criteria for that, it's called the cell hearing, and you can look up the USP cell if you wanna see it, but. So there can be a treatment side of it, and it can be forced if the court authorizes it.
They could also just take medication voluntarily.
Yes, they could.
If they want. Okay.
And so right now it's only Advertise, jail-based or ASH that will do those restorations.
Yeah.
So it's SB 1710,
Which one?
the ASH.
The secure.
It's under the same one as the doc.
Thank you.
And if it's not that one, we'll correct ourselves later. But I do think it's that one.
Probably.
Anything else? Any other question?
I don't have any other questions in the chat. I don't know if anyone else has any other
I
questions.
was told to disclose this because I was sitting there listening to these guys talk. We are flabbergasted constantly when we go in the community that people are not aware that the guidance center is the only holder of the Title 36 contract in Coconino County. So if someone gets titled, they must and can only come to the guidance center. We can't go to FMC, we can't transfer them to a different hospital, even if we're full. So we're capped at 16 beds for all of Coconino County.
So is Page PD's driving them down?
Yep.
Middle of the night sometimes, whatever.
We also can't title anyone on sacred land.
So they have.
So we occasionally get people who have been coached to come down from reservation. And there's absolutely nothing that we can do.
What I'll say there is, we can't procure their absence. The reservations of sovereign nation and has its own amendment clause. We don't have to provide them. They turn up here anyway. Okay, but we will have nothing to do with trying to take them off of a reservation. For tribal sovereignty reasons, and in addition, there is a process by which tribal court orders can be domesticated here, which is a whole other topic. Upset about how to do that, so.
But that piece was to really explain how that process flow works with 16 beds and demand far exceeding that capacity. There are a lot of wait times, and in fact, we are experiencing that currently. As I mentioned, our hospital is full right now, and we had 4 people moving over today from the other hospital to make it through this process, so. It's constant, this is not a rare process for us at all.
Yeah, and, we have to still follow. Basically access policies for, they're the ones that we take out the funding for treatment regardless of whether the evaluation sign contract, and yeah. Capacity will be a challenge. Due to federal issues beyond our control, which basically says define as final as anything that has more than 16 beds. So, because we don't want federal money going to support asylums. That's the Fed saying, Congress, if you state, if you want to know, you pay for it, right? So hence the bed cap. So it actually says, okay, emergency application comes in. And it appears meritorious. You need to admit them as soon as you can, once you have capacity, and assuming they have no other physical medical needs that need to be addressed first.
So we talked about applications coming in, who are filling out the applications?
Well, it could be any. I mean, there's no standing limitation here. However, it tends to be police, ED, jail, and in addition, the terrorism and mobile crisis system that CareFirst has set up is real help in that helping people fill things out or even being the applicant potentially. So yeah, anyone can apply. But in terms of the quality application, especially in emergency, you've got to determine the reasonable amount space that's presented to us. So it can be nice. A lot of people do avail themselves of the mobile system to assist with that.
So the guidance center will also build them out to for many of our members who we have to do an outpatient crisis.
We could do we can't do that in the non-emergency ones, because there has to be a pre-position screening. We tried it once, that's like, you can't interview yourself. So we couldn't do that. But the emergency ones, obviously, they can still be the applicant because you might come here first voluntarily, if they could try to leave.
And we will also assist community members. So we make that process easy. A lot of people don't know how to file an application for involuntary commitment, so we help them with that.
So say somebody's not restorable, not confident, not restorable. Under what circumstances would you guys consider filing your own application for a title?
Well, as I mentioned, anybody could apply, right? And it would start that initial application process. On the other hand, if we have a formal non-restorable finding, this is not, oh, they're not competent and I don't want to spend the money to send them to restoration, so I'm just going to drop the charge. This is they went to restoration and it failed, or they were found right at the outset, literally found to be not competent and not restorable, right? That's the court finding. Then it's a direct file. That's where they order the CCAO to file the COE petition right off the bat, as you saw in the earlier slide, assuming the court goes for that option.
I would add to that two things. One, the first thing is that like oftentimes. When we get an order for Rule 11, the person is completely unknown to us, right? So I'm evaluating them for the very first time. They might not even be from Northern Arizona or Arizona at all. And so, we wouldn't necessarily always be the best applicant if it was appropriate to title them. And then secondly, the only thing that I would add is I might opine to the court that I believe this person is not competent and not restorable, and the judge might disagree with me and say, well, we're gonna make an attempt at restoration. Or even if the judge does agree with me, then they typically will order what they want to happen next, whether that's a guardian or an application for title or.
And what they'll order, like I said, in those circumstances, if it's NCR, it's gonna be a direct file. So there won't be an application, there'll just be a court evaluation. And like with the other non-emergency ones, we're gonna have 14 days to begin it, and then the conventional 72 hours to finish it.
For COT, you might have said this and I missed it. Do they automatically get appointed counsel, or is it only if they're can afford it?
No, it's automatic.
Okay.
Now, of course, they can hire private if they wanted to. I've never seen someone actually do that. But there isn't an indigency requirement. So they're gonna have counsel appointed. Typically, like I mentioned earlier, almost all of these evaluations take place inpatient. The triggering event tends to be the physical confinement, so if it's theoretically possible to have an outpatient evaluation, even though it's almost never actually used because it doesn't really work, but if the court were to order that, that can affect the timeline of when their appointment is, but as a practical matter, counsel is going to get appointed with COE issue or order of issues.
And is it the public defender's office that gets the contract?
Right now, legal,
Okay.
hence Joanne's visit the other week. So.
I don't have any questions in the chat. I don't know if anyone else has any questions.
Do you know how much it costs to restore someone?
Oh my god, I do not, but I've just heard
It's a lot.
It's very expensive.
yeah.
I know that there's someone I have right now that's probably not gonna pass a Rule 11. I think she's not gonna be competent, but she's on for such a unserious offense. I don't think that.
I mean, all of this costs. There, whether it's Title 36 or Rule 11, hospitalization is extremely expensive. I think that's why the anti-jail restoration program was created, was to try and be a cheaper alternative to ASH. That's not to say it's inexpensive, but
I bet Eric knows.
Well, as when our judges sent both sides for ASH, I typically cite the cost as a reason for Yavapai.
yeah.
They say ASH is expensive, it's too expensive, therefore Yavapai, that's what we usually hear, so I assume it's be cheaper to go to Yavapai.
Yes, yeah, it's cheaper.
And who absorbs the cost?
The county,
The county.
The court?
the county,
Just the county, the big county.
Coconino County absorbs the cost.
Yeah.
We should pertain for the Title 36 evaluation up to the filing decision for COP anyway.
So that's why I made a little note on the one slide that says like the judge can elect to drop the charges. I evaluated an individual who did speak English and was hard of hearing. And even though I thought that they could probably benefit from restoration, those restoration conditions don't exist. And therefore, the judge made the determination that they agreed that the cost wouldn't be worth it to try to send someone to a class that they're not gonna benefit from. And so even if we believe it's possible, it doesn't always happen.
Thank you guys so much. We appreciate it. Thank you, everybody
Thank you.
who's on Zoom for being here. And we will be sending up a follow-up email with the certificate for CoJet as well as an evaluation. Thank you guys.
Thank you.